Hello, welcome to On Point with Your Legal System. My name is Gary Mack. Our show is designed to give you an overview on a variety of legal problems and concerns. Today's show is just a little different than our usual one. It's the case of the heir's intentions. We've created an almost true-to-life court case, with the outcome up to a jury of just regular people. The attorneys and the judge are the real ones, and the witnesses have volunteered to help us create our case. Remember, the outcome of what you're about to see is unknown until the jury deliberates and returns its verdict. Let's go now to the probate courtroom of the Honorable John Monahan.
Ladies and gentlemen, it's a pleasure and a privilege to have you each here as a prospective juror in the St. Clair County Probate Court Evening Division. My name is John Monahan, and I am probate judge for St. Clair County. You've been called here today, all of you, for possible selection as a juror in a civil case. The remarks which I am about to make are intended to be an outline of the trial of this case, so that you may become generally aware of what occurs during a trial and some of the legal principles that control the conduct of civil cases. This case before us tonight is a will contest. The person who presents the document claiming it is the valid will of Mary Winkle, the decedent, is called the proponent. The term decedent is used to refer to the person who is deceased. The proponent is Charles Minkle. The attorney for the proponent is Mr. Flanagan. The person who contests the document, claiming it is not the valid will of Mary Minkle, the decedent, is called the contestant. The contestant in this case is Betty Minkle. The attorney for the contestant is Mr. Nelson. Allow me to dispel from the beginning a common myth. Property in the sole name of a decedent must go through probate, must go through the process in order to transfer title to the asset. In the case of Mary Minkle, she left a 200-acre farm in her own name. If the deceased leaves no last will and testament, the estate passes by intestate laws of the state of Michigan. In this case, she being a widow, the property would go to the two children of Mary Minkle. However, anyone can prepare and execute a last will and testament, leaving property to whomsoever he or she pleases. A document purporting to be the last will and testament of the deceased must be admitted to probate. A petition is filed, as in this case, by Charles Minkle, asking for a court order determining that the document offered is, in fact, the last will and testament of the deceased. In all cases, all parties who would take the property if there were no last will and testament, these are called intestate heirs, and all beneficiaries named in the last will and testament, all are notified. Objections may be filed if anyone sees a reason why the will should not be admitted. In this case, Betty Minkle has filed objections to the admission of the last will and testament, and that is what this trial is about tonight. A trial begins with the selection of a jury. The purpose of this selection process is to obtain information about each of you so that a fair and impartial jury can hear this case. If you are selected, you will be sworn to justly try the case and enter a true verdict unless dismissed by the court. This process is called voir dire, to speak the truth. The attorneys and I will ask you certain questions, but first I want you to take a preliminary oath, those of you in the jury box. Would you each raise your right hand, please? Do you solemnly swear or affirm that you will true answers make to all such questions as may be put to you in regards to your competency as jurors in this action? All have indicated the affirmative. Are each of you citizens of the United States, 18 years of age or older, and a resident of the county of St. Clair? All have indicated affirmatively. Are each of you conversant with the English language? Affirmative. Are each of you physically and mentally able to carry out the functions of a juror? Have any of you served as a grand juror in a court of record during the past year? Are any of you under sentence for a felony presently? Do any of you claim an exemption by virtue of being more than 70 years of age? All have asked appropriately and are all qualified. Each of you has the requisite qualifications to serve as a juror of this court. The case is now set for hearing in the matter of Mary Minkle. Is counsel for the proponent ready?
We are ready, Your Honor.
Is counsel for the contestant ready?
Yes, Your Honor.
As stated earlier, the case we are about to hear is for the purpose of determining whether the document purporting to be the last will and testament of Mary Minkle shall be admitted to probate. You will be given specific instructions as to legal requirements of a valid last will and testament at a later time. Mr. Flanagan, would you care to voir dire the panel?
Wouldn't that be the proponent's choice to go first, Judge?
Yes, it is. Excuse me, Mr. Nelson.
Your Honor, I'm the contestant, and Mr. Flanagan is the proponent of the will. As I informed the court prior to the opening of trial, we are going to waive our voir dire in this case.
I choose not to waive the voir dire, and I assume if the opponent, who calls himself the contestant, waives, he waives without a response to my voir dire. I'd ask the court's ruling.
I'm going to voir dire the panel myself.
After my voir dire, Your Honor.
Yes,
But that doesn't give the opportunity for the contestant to voir dire, does
that
it?
is correct.
Thank you. A voir dire is to find out whether you're particularly qualified to serve on this jury. The comments by His Honor moments ago makes you qualified to serve generally as jurors, but that doesn't make you qualified to serve in this particular case. And so, to lead into some questions, I'm going to have to make some comments about what this case is about. This case is about my 45-year-old client who stayed home on the farm and took care of his mother for those 45 years, and she willed the farm to him. While his sister traveled to the University of Michigan, obtained a medical degree, and then flew on to Colorado and practices medicine in between her skiing ventures and periodic phone calls to her mother.
Your Honor, if I may, it appears to me as though Mr. Flanagan is starting a little early with his opening statement. I don't mind an opening statement, but to attempt to influence the jury right off the bat with his voir dire comments, I would object to that.
That leads to a question, Your Honor, and I'm almost to that question.
Let's lead a little more promptly in the future questionings.
Thank you, Judge. Anybody on the jury panel have that kind of experience like my clients had? Ever had to care for a parent? Ever had to stay home and take care of your parents? Pam, you have?
I've looked after my parents.
You look after your parents? And did you have to look after them into their late years? Where did that occur? Not to be nosy, but where were you folks located? Were they farmers?
Marysville. No, they were not farmers.
Where were they?
In Marysville.
In Marysville. Did you go into their home and live with them?
No, I brought them into my home.
You brought them into your home, and you cared for them? All right. And did you have brothers and sisters? Did you get any help from your brothers and sisters?
Some help.
Some help. And are your parents still living?
No, they're both deceased.
When they passed on, did they leave a last will and testament?
Not as such, no.
Did they leave their estate to anybody in particular?
No, it was split among all surviving children.
I see. Were you satisfied with that disposition of your parents' property?
Yes.
So you were willing to care for your parents and then see their estate divided among your brothers and sisters? Anybody else that kind of an experience? Yes, ma'am.
Sir, I took care of my mother in a nursing home. I went there 3 times a week.
All right. Do you have brothers and sisters?
Brother.
Did your brother help?
Yes.
And is your mother living today?
No.
And was her estate left by will?
She was in the
No estate to leave? So you didn't have that kind of an experience that I started out talking about with?
just an elderly.
I beg your pardon?
Just an elderly parent to take.
Let me go to the next question, okay? How many of you folks are parents? How many of you have children? Everybody but one? Sir, do you have adult children?
Yes,
And how many adult children do you have?
2.
And do they live in the community or in the community near you? Where are those children?
One's in California, and the other's in West Bloomfield.
Detroit area, West Bloomfield? Okay. And you're in good health and able to take care of yourself?
Yes.
And you live in your own home? You haven't had to call on your children to help you?
No.
Have you decided what to do with your estate, sir?
Yes.
Have you done so by will or living trust?
I will.
And the choices you made in that will, are they your choices?
Yes.
Would you want someone to later challenge your choices after your demise?
No.
That's what this case is about, you understand? You understand that? Can you fairly assess the evidence
Yes.
of this contestant's claim to overthrow her mother's will and be fair and impartial and come to a proper decision? Thank you, Judge.
I'm going to ask you collectively, in this case, the objection filed by Betty Minkle alleges that Charles Minkle, the son, exercised undue influence on his mother and made to his mother misrepresentations of material facts and exercised such influence that the free will of Mary Minkle was overpowered. Now, have any of you heard the allegations made in the objections to the last will and testament before today? Do any of you know anything about this case through your own personal knowledge or by discussion with anyone else? Do you have a state of mind with reference to the objections against this will which would in any way prevent you from acting with impartiality? Do you feel that you can eliminate and disregard everything that you have heard or read pertaining to this case and render an impartial verdict based solely upon the evidence presented in this courtroom? Now, as you know, Charles Minkle is the proponent of the will, seated with Mr. Flanagan. Betty Minkle is the contestant of this will, seated with her attorney, Mr. Nelson. Have any of you met either Betty or Charles Minkle before tonight? Yes, sir.
In People's Law class and also in court, I was on jury duty. She was on the case this month.
Would that contact with her cause you to review the facts and be prejudiced in any way, for or against her? Do any of you know either of the attorneys involved in this case?
I know Mr. Nelson.
I'm sorry, who's?
I know Mr. Nelson.
You know Mr. Nelson. In what capacity do you know him?
I know him as the officer with a trust that I'm involved in.
Would your knowledge of Mr. Nelson cause you to give him greater or lesser weight to the evidence presented by him? I'm going to name the witnesses that are likely to be called in this case. Attorney Philomena Everglade, Dorothy Smith, Frank Shelby, and Thomas Shelby, besides the parties to this case. Do any of you know any of these people? Are any of you related by blood or in any other way have contact with them? Do any of you have any physical defects, hearing, sight, or otherwise, which would render you incapable of performing your duty as a juror in this case? Do any of you have bias or prejudice, either for or against the contestant? If you are selected as a juror in this case, will you render a fair and impartial verdict based upon the evidence presented in this courtroom and the law as it pertains to this particular case as instructed by the court? Do you have any reason why you cannot give this case your undivided attention and render a fair and impartial verdict? Counsel, do you have any challenges for cause?
I have no challenges for cause, Your Honor. All the jurors are acceptable.
Mr. Flanagan?
And no challenges.
At this time, then, I will swear you all in to try the issues of this case. Would you all again raise your right hand, please? Each of you do solemnly swear or affirm that in this action now before the court, you will justly decide the questions submitted to you, that unless you are discharged by the court from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instructions of the court, so help you God. Now that we have a panel, the remainder of the panel are discharged. You are free to remain in the courtroom and view the remainder of this trial. Gentlemen, do you have any motions for sequestration?
No sequestration motion, Your Honor, but I do have a motion concerning the evidence.
All right. You may bring forward that motion at this time.
Do you want a sidebar on the motion? I don't want to argue this motion in front of the jury.
I have no objection to a sidebar on the motion.
Very good. Over here, gentlemen.
He proposes to offer this deposition and I would object to it because it's hearsay. What, if anything, did Mary tell you on medication concerning transmitting substance nursing? That's hearsay. Can I do this straight to the question and answer?
You do?
This, I'm going to move to strike this question and this answer. His opinion about what he thought was fair, unfair, or otherwise is not relevant.
I agree. That's all.
Okay.
So the only other thing I want to strike that hearsay.
Which one was the other one? Yeah, yeah. It's not a
Is it?
matter, sir.
Well, that's hearsay. It's made out of the presence of my client. It's not in his presence. And if it's not in his presence, it's his presence.
Since concerning charge, it doesn't say about the term legal side. It just says concerning charge.
It's sure, exception to the record, right?
There are points in a trial where counsel for both sides will have disagreements as to what is admissible evidence, and rather than argue these points in the presence of a jury, would defeat the whole purpose of excluding the evidence if it was inadmissible. Mr. Flanagan has asked for a couple of exclusions of evidence. He has succeeded in one of his motions, he has failed in the other point, and he has put that on the record. So that will be perpetuated, Mr. Flanagan.
Thank you, Judge.
You're welcome. I want to speak with you briefly now about the functions of a judge in a civil trial and your functions as jurors. You've been sworn as a jury to try this case. By your verdict, you will decide the disputed issues of fact. The court will decide the questions of law that arise during the trial. And before you retire to deliberate, at the close of the trial, the court will instruct you on the law that you are to follow and apply in reaching your verdict. The court's responsibility is to conduct the trial of the case in an orderly, fair, and efficient manner, to rule on questions of law arising in the course of the trial, and to instruct you as to the law which applies in this case. Let me briefly explain the order of procedure. First, the attorney for the contestant makes an opening statement in which he outlines his theory of the case. The attorney for the proponent has a right to cross-examine witnesses called by the contestant in order to test the truth and accuracy of their testimony or to elicit testimony favorable to the contestant. Following the contestant's presentation, the proponent has the opportunity to present evidence. Similarly, the attorney for the contestant has a right to cross-examine witnesses called by the proponent. After all the evidence has been presented, which is in the form of the testimony given, the attorneys for each side will have an opportunity to present closing arguments to you in support of their cases. You are reminded that the statements of the attorneys in closing arguments, as in opening statements, as in voir dire, are not evidence, but are only intended to assist you in understanding the evidence and the theory of each party. You must base your decision only on the evidence given. Following the closing arguments of attorneys, I will give you final instructions on the law governing this case, and you will then retire and deliberate on your verdict. You will do that by applying the law to the facts as you find them to be. The function of the jury is to determine the facts. You are to weigh the effect and value of the evidence as well as the credibility of the witnesses. You must consider and weigh the testimony of all witnesses who appear before you, and you alone are to determine whether to believe any witnesses and the extent to which any witnesses should be believed. It is your responsibility to consider any conflicts in testimony which may arise during the course of the trial. Your decision as to any fact in the case is final. On the other hand, it is your duty to accept the law as the court states it to you. Your determination of the facts in this case must be based upon the evidence which is offered and received. Evidence consists of the sworn testimony of the witnesses. It also includes any exhibits which may be offered into court and received. Your function as a jury is every bit as important as the function of the court and the attorneys. You should therefore give careful consideration to the testimony as it is received and presented for your consideration. You should keep an open mind and not express any opinion about the case until you have heard all of the evidence, the closing arguments of the attorney, and the instructions as to the law, and until you have retired to the jury room to consider your verdict. Sympathy must not influence your decision, nor should your decision be influenced by prejudice regarding race, sex, religion, national origin, age, handicap, or any other factor irrelevant to the rights of the parties before you. You must not discuss the case with anyone, not even members of your family or your fellow jurors. When this trial is over, you may discuss this case with anyone you wish. The only information that you will receive about this case should come to you while you are all together as a jury, in the presence of the court, the attorneys, and all parties involved. You must not consider any information which may come to you outside this courtroom. The trial follows established rules of procedure and evidence. The attorneys are trained in these rules and may from time to time make objections and motions when it is their duty to do so in representing their clients. You've seen an example of that already. I will rule on these objections and motions. Most of the time I will make these rulings in your presence. You should not conclude from any of my rulings that I have an opinion on the case or that I favor one side or the other. If I sustain an objection to a question and do not permit the witness to answer, you should not guess what the answer might have been, nor draw any inference from the question itself. I may give you additional instructions during the course of the trial, and I will give you detailed instructions at the end of the trial. All of these instructions are important because together they state the law which you are to apply to this case. Please let me know immediately if you cannot hear a witness or see what is being demonstrated. Mr. Nelson, are you ready to proceed?
The contestant is ready.
Mr. Flanagan?
Yes, Judge.
Mr. Nelson, you may proceed.
Thank you. May it please the court, ladies and gentlemen of the jury, my name is Doug Nelson. I'm representing in this matter Betty Minkle, who is the daughter of the decedent, Mary Minkle. Mary Minkle died on March 17th, 1991. Roughly 2 months prior to that, she had executed what is purported by Charles Minkle, the defendant in this case, to be her last will and testament. We will, throughout the course of this trial, show to you positively, beyond any reasonable doubt, that Charles Minkle unduly influenced his mother, and he did so to such an extent as to overcome her free will to execute a will. We will also show that in doing so, he committed a fraud upon his mother in misrepresenting many facts to his mother concerning matters that were very important to her that influenced her decision in executing this will. By the time this trial is over, there will be no doubt in your mind that Charles Minkle unduly influenced his mother and did so through fraud. Thank you.
I guess I have to respond, and the only thing I can say is that I agree that this fine lady passed on March 17th, and praise the Lord that her son was able to take his mother to a high holy mass on St. Patrick's Day, and she died later that day because he was a caring, loving son right to the day and the time of her death. 45 years of caring, and caring to stay at home, an Irish bachelor, so to speak, didn't get married because his obligation was to his mother. And if you're Irish or know the Irish, that's one of their downfalls. I'm Irish and I speak with authority. You make sure that your parents are cared for. While he was being sure that his mother was cared for, she was being sure that he was cared for, and that's why she left this will. And that's why she left this estate to her son, and not to her daughter, who is a physician, who's a board-certified specialist in dermatology, who is in Colorado and devotes her time to caring for the sick and skiing on her off days and calling her mother on occasion. I think when you're done with this case, you'll have no conclusion but to conclude that you should honor Mary Minkle's wishes. You should say, yes, this was her will, and yes, this is what should be done. That's the only issue you have to decide. And I'm sure you'll decide it properly. Thank you.
Mr. Nelson, you may open your proofs.
Are we ready for opening proofs, Your Honor, or do you want to have a short recess at this time?
We could take a short recess at this time.
Thank you, Your Honor.
Hi, I'm Richard Dysart. Each week, television drama depicts the efforts of the legal profession to provide equal justice to all. Today, all across our country, a real-life endeavor is taking place. Lawyers are volunteering to provide pro bono, that's free, civil legal services to our nation's low-income citizens. If you're a practicing attorney, join the pro bono movement. Help improve the quality of life in your community. Call this number today.
Please, the court, Your Honor, at this time I would like to call the contestant, Betty Minkle.
Raise your right hand, please. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Proceed, please.
Would you please state your name and address for the record?
My name is Betty Minkle. I live at 111 Aspen Way, Aspen, Colorado.
Could you tell the court and the jury what your occupation is?
I'm a dermatologist.
And how long have you been in that occupation?
Since I got out of school, about 15 years.
And has that always been in Colorado?
Yes, it has.
Okay. Prior to becoming a dermatologist, what had you done?
I went all the way through school, so I was in school and then a resident and then I specialized.
And so you were not employed prior to being a dermatologist?
No, I was not full-time, only while I was in school.
Okay. Were you related to the decedent?
Yes,
And what way were you related to the decedent?
I am Mary Minkle's daughter.
And during that period of time in which you were growing up, did you reside in the home in question?
Oh, yes, I did.
And for how many years was that?
Until I went away to college after high school at 18.
And during vacations, did you come back to the home?
Yes, I did.
And summer vacations?
Yes, I came home in the summer and then worked and helped around the home and worked outside of the home while I was home on vacation.
So that you were working through all this period of time?
Yes, I was.
Okay. How would you describe your relationship with your mother? Would you say that you had a good relationship, or average, or what?
Oh, Mother and I had a good relationship. I was the second child. My brother is a few years older than I, and I think that if Mom had had her way, she might have had two boys, not a boy and a girl, but we had a good relationship, and Mother and I always got along fine.
Okay. How would you describe the relationship of Charles Minkle to his mother?
They had a wonderful relationship. Charlie always was Mom's favorite.
And did Charles do all those things that counsel described that he did in their opening statement?
Oh, yes, Charles certainly did. Charles took care of Mom.
And he was very good to her.
Charles was very good to Mother.
In what ways was he good to her?
Well, all the time that he was home, I know he always did help around the house. After Dad died a couple of years ago, Mom sort of went downhill. He died very suddenly of a stroke. And Mom wasn't old. Mom was only 65 when she died. But after Dad died, she just almost seemed to lose the will to live. They'd been married all of their lives, it seemed. And Charlie did do things for her. I know he handled her checking account. She didn't want to bother anymore. Dad had done most things for her, and she looked to Charles to do all the things that he had done. And Charles did do them.
Would you say that your mother had trust in Charles?
I would say she had absolute confidence in Charles.
Did he also help his mother around the farm?
I don't understand. Around the farm?
Were they operating the farm
Oh,
as a
no.
family farm?
The property that we lived on was the old family farm, but it hadn't been operated as a farm by my family for a generation or more.
Was the farm being agriculturally developed at the time? If the family wasn't doing it, was it leased out?
It was leased out, yes, and Charles took care of the leases for Mom, but we had not done anything as a family on that farm.
So that Charles also helped his mother with the leasing of the farm?
Yes.
How about the household expenses? Did Charles contribute to the household expenses? Do you know?
I don't know, but since Charles rarely worked, I don't know how he could have.
In your profession as a dermatologist, you are a licensed MD in Colorado, is that correct?
That's correct.
Would you describe your practice as successful?
As successful as one can be operating a free clinic for the poor.
How much do you make on the average with your clinic?
Approximately $70,000 a year.
Approximately $70,000.
That's correct.
Is that before tax or after tax, or is that your net?
Well, that would be the net for the operation, but then that would be prior to my paying tax.
Okay. Did anyone else live at the farm with your mother and Charles?
Not after my father died, no. They lived there alone together.
So how much time, on the average, would you say that Charles spent with his mother?
From what I know, after not having lived there for quite some time, Charles spent most of his time at the farm with my mother because it's my understanding that he very rarely held a job, so he was home most of the time.
Okay. When was the last time you spoke with your mother?
Around Christmas.
And did she appear to be well at the time you spoke with her?
From what I got over the phone, she was well. She was not happy to be alive without my father. But as far as physically good health, yes, I would say she had physical good health, except that she told me that her eyesight was failing and that it was very difficult for her to read. And she was worrying, I think. She sounded distraught almost.
Did she give you any reason for feeling distraught?
She only said that things were with Charlie like they usually were with Charlie.
Like they usually were?
Yes.
Did she ever describe to you how Charlie usually was?
Well, throughout the years and throughout Charlie's history, although he and Mom were very close and she loved him dearly, I guess sometimes I got the feeling that maybe he was smothered or for some reason just didn't feel that he could go out on his own. All the time that Charlie was growing up, he didn't make friends easily. And when he was a teenager, he even tried to commit suicide once. He just wasn't a very happy boy. So when she told me that things were usual with Charlie, I guess I assumed that that was what she meant. And then I found out later that that was what she had meant.
How did you find out later?
Well, Mother and I always wrote letters at Christmas and wrote letters most of the year if we didn't speak to each other. And I got a letter from her around the first of the year.
Would this happen to be the letter that you received from your mother the first of the year? Can
Yes.
you identify that?
Yes, that's it.
And is that your mother's signature?
Yes, that's Mother's, the whole letter is Mother's handwriting.
Your Honor, if I may, I'd like to move for the admission of contestants exhibit number 1.
Excuse me, Your Honor. May I voir dire the witness on this letter?
You may.
Doctor, this is a letter to you,
Yes, sir.
purportedly from your mother,
Yes.
dated January 1 of 91.
Yes.
And Doctor, when did you discover this letter?
Well, I received that letter just after the first of the year from Mother.
I understand that, but it's just come to your attention now, this letter.
No, sir.
Doctor, your deposition was taken, and I've reviewed the deposition notes, and there is no testimony by you concerning any such a letter.
Objection, Your Honor. The deposition has not been admitted at this time. In fact, there has been no motion to admit any deposition at all. If he's basing an objection to this letter, the counsel had adequate opportunity to discover through interrogatories and requests to produce this letter. We had it in our possession at all times. He failed to do so. It was well within his means of discovery. I would like to move for its admission.
It's not in compliance with the court's pretrial order, Judge. The court's pretrial order requires the parties to exchange proposed exhibits. I've never seen this exhibit, never heard of it until this very moment. And on that basis, I ask the court to keep it out as a matter of pure fairness.
Your
I mean,
Honor,
that's underhanded to lowball us here at trial.
I may also point out to the court, Your Honor, that just before trial, I was handed a copy of a deposition that I had never seen before.
I was likewise, Judge, the same deposition.
And I'm assuming that if that deposition would be admissible, that there would be no objection to the admission of a letter in the handwriting of the decedent indicating and written to her daughter at Christmas time that she does every year.
Let me see the letter. View of the pretrial statement in which counsel were ordered to exchange all exhibits 30 days prior to trial so that these types of matters could be taken care of and attended to before trial time. This evidence will be excluded.
Thank you, Your Honor. When you were speaking with your mother, she indicated to you that Charles was in his usual state of mind. And I asked you earlier what that state of mind was. And if I recall, prior to this letter being proposed, you indicated that he had been despondent. Is that correct?
That's what she told me. I was not home, so I don't know.
And did she give you any reason for her observations or feeling that he had been despondent?
He had been unemployed again for a long period of time, and I suppose Christmas time had something to do with it too. Charles always became rather withdrawn and reticent at Christmas, and especially after Dad died too. Things seemed to get worse for him.
Did she indicate to you any other reason that she might be concerned about him?
Just that he was voicing his discontent with life and his woe is me attitude that unfortunately has been lifelong. I've seen that for myself when he was growing up and when I've been home.
How often did you see your mother during the year?
Oh, I got home probably a couple of times a year, and other than that, either she would come to visit me once in a while, or we would write frequently, and I'd call her on the phone, or she'd call me at least monthly.
At the time you visited, did you stay on the farm?
Yes, I did.
And was Charles there at the same time?
Oh, yes.
And did you have the opportunity to observe Charles while he was in the farm?
Yes, I did.
And at that time, did you see the same things that your mother had noted to you with regards to Charles's state of mind?
Charles always had almost a helpless quality about him and just seemed like life was overwhelming him. And yet, Charles could and did take over things as he did for Mom after Dad died. So he was perfectly capable. He did a good job with what he was doing for Mom. We talked about it when I came home, and he was there. It was fine with me that he was helping her out. I was certainly glad he was.
After your mother died, where was the funeral held?
The funeral was held here in town.
Okay, and did you attend the funeral?
Yes, I did.
And after the funeral, was there a reception?
Yes, there was.
And did you get the opportunity to speak with any of the neighbors?
Oh, most of the neighbors and all of the Mom's friends were at the funeral and the funeral home and at the reception.
Did any of the neighbors approach you with regards to an offer that they had received on their farm?
You know, it was surprising. Mother had never mentioned it to me, but apparently Mr. Jones, the next door neighbor, told me that a large corporation was coming through and had made him an offer on his property and asked me if we had received as good an offer on Mom's tract of property as he had gotten on his.
Did he indicate to you what that offer was?
Well, he told me that his property was only about half the size of Mother's. He had about 100 acres, where Mom has about 200. And he said that he had been offered well in excess of $1 million for his 100 acres.
Okay. And subsequent to that, did you, in fact, follow up and contact the corporation that made that offer?
Yes, I did.
And what did you find out?
I found that, well, they sent me a copy of correspondence that they had sent to Charles, indicating that they were willing to make an offer in excess of $2 million for our property.
So that $2 million is substantially in excess of what the petitioner indicated on his petition, being $240,000.
Yes,
Is that
sir.
correct? I have no further questions to the witness, Your Honor.